have a seat, no problem. You coming in, sir? That's fine. We haven't started yet. We haven't started. Don't worry, take your time. Mr. Hadamio, which case are you here on? Mr. Cooper. Okay. Okay, so now let's call up Mr. Cooper. Do you know what page that's on?
Sorry, Judge, I didn't even.
Page 7.
Thank you.
Okay, thank you. We're calling up first to Mr. Cooper, I think it is.
Yes, Judge.
Joel
Cooper.
He's here, President Judge. Private counsel there, Mr.
And is that Maine? Hello, yeah, private counsel is here for you, Mr. Cooper. All right, Mr. Cooper, the charge that is alleged is that you are, do you want me to read it out loud? It's up to you.
Judge, we're here to argue as far as bond goes. I know the charge came from a warrant that was issued in Brevard County.
Okay.
So I'm not going to argue as to probable cause. But
do you want me to say out loud what it is based on the nature of it? Some people
No,
don't.
Judge.
Okay, you waive that?
Yes.
Okay. Now, the question is, may I ask, it doesn't really say that it's a no bond. It says that I can choose a bond. So
Yes,
my
Judge.
question then for the state would be, what is his criminal history? Obviously, the nature of the charge gives me some indication, but I don't know what else there is.
Right.
So, Mr. Linder.
Your Honor, the only prior, I mean, he had an old trespass and disorderly conduct, but his only significant prior is
this
the
one?
underlying offense that led to his
Arrest. All right.
registration.
Well, for purposes of the record, sir, your attorney is waiving the formal reading of the charge, you know, basically to avoid any type of embarrassment. We have an audience here, okay? Is that all right with you, sir? Does Mr. Cooper understand?
Yes, I'm not embarrassed.
You're not embarrassed?
Mr. Cooper, do you want the judge to read the charge to you?
Do you know what the
No, I
charge?
know what it is. I'm fine.
Right.
I'm fine.
You don't
have
need-
to read it. I was just saying. No,
Okay.
Just go ahead and proceed, but I'm fine though either way.
All right. And so what is it that you think is a fair bond, Mr. Hadamio?
Judge, first I wanted to tell you, he's from Florida. He lives in Brevard County. He's lived there for 31 years. I think his ties to the community are significant. He has a company here where he details cars. He's registered with the state of Florida. He has 2 children. One goes to college in Tampa. His whole life is here. I don't think he's going anywhere. As
The
far as
allegations are he just didn't register the residence in North Lauderdale.
That's the allegation, Judge.
Yeah.
And the last prior, although significant, as you see, it was in 2002. So there hasn't been anything significant in between. We wanted to ask the court to consider, Judge, pretrial release, ROR him to pretrial release. I just talked to his folks in Vieira, and they don't have a lot of money to bail him out. His mom is disabled and 78 years old. He takes care of her part-time over there, pays the mortgage of her house, and they just don't have a lot of money to post bond. We're hoping that maybe with pretrial, that way he'll be supervised as well, Judge.
Well,
Your Honor. Your Honor.
State, want to say anything?
Yes, Your Honor. My concern is that Mr. Cooper really doesn't have ties to South Florida, Your Honor. I've got concerns about his future appearance in court just by the nature of the offense, Your Honor. He's got one residence. He's got a listed residence in one area that's not in South Florida. I believe it's Cocoa. Then he's living in another residence in South Florida. Then apparently he moves without making any kind of change to his information and ends up getting arrested in Brevard County, Your Honor.
All right. Well, I think that under the circumstances and what I've heard, I think a $1,000 bond is fair. I do find probable cause for the arrest. He'll have to address not only this case before me, but the one in Brevard County.
Sounds good, Judge.
Any questions or concerns?
No, there's no pretrial release involved, right?
Nope.
Okay, because he
I
had
didn't go with that. I feel if he's got to travel to the other part, and I don't want to put him on a GPS because that's what I'd have to do, and I'm not.
Yeah, he has to travel to Las Vegas too this weekend, so
Again,
we're good.
That's why I chose. You said he had a place as a business. I just decided $1,000 bond is fair, knowing his history.
Very fair.
Having not gotten in trouble in a long time, I went with that.
Thank
All
you,
right,
Judge.
Thank you. Good
Thank
to
you.
see you, Mr.
Good to see you
Hadamio.
as well, Judge.
All right. Thank you, sir. Good luck. North Broward, you ready?
Yeah, is it okay if I see one guy out of turn?
Sure.
He's an old man, he's sick in a wheelchair. He's on the second book, though.
That's
Not on
fine.
the regular docket.
That's okay. Second.
McCorak.
Okay.
Stephen McCorak. Come on.
Page 2 of the second look. First one on the dot. Hello, is it Mr. McCoryak? Let me ask, he's been in 9 days according to this.
Yes, Your Honor. He was also being held on a felony, but it looks like he was placed on probation on that case, so this is the only thing holding him.
That's correct, Judge. He did resolve his case yesterday for 4 years probation as he's proudly holding up his paperwork. There are many reasons why the court should time serve Mr. McCoriak on this charge.
Is it filed?
No, Your Honor.
You know, he'd be taking a plea to a case that's not filed. I mean, that's okay with me if it's okay with him.
You want time served on this, Mr. McCoriak, on this misdemeanor that's holding you?
Actually, it was going to be filed, Your Honor. I can see.
Okay. They are going to file it. Would you like to plead either guilty or no contest in order to get to the time served offer of adjudication, 9 days, Broward County Jail, credit for time served of 9 days, but you have to pay court cost. Okay?
How much, Your Honor? How much?
How much is the court cost? $293, but I'll give you a year to pay.
You got it.
And how do you plead, sir? No contest or guilty?
Yes.
No contest. Okay, I'm going to ask you some questions, but first I need you to raise your right hand. That's the other right hand. That's it. Raise your right hand. That's it. Do you solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth?
Yes, Your Honor.
What's your name?
Stephen Michael McCoriak.
And sir, how do you plead to the charge of trespass after warning?
No contest.
All right, sir. You understand it's not filed right now, but they say they are going to file it. Do you understand?
Yes.
All right. So you're pleading no contest to that charge. Is anyone forcing you or threatening you or coercing you to plead no contest?
No, I had problems with the firmer.
Okay, but can you hear me? Can you hear me?
Yes, Your Honor.
Is anyone forcing you or threatening you to make you take the no contest plea right now?
No, Your Honor.
Okay. Are you under the influence of any alcohol, drugs, medication, or anything at this time that would make you not understand something?
No, Your Honor.
Okay, you're pleading no contest. Do you understand by pleading no contest there will be no trial in this case? No witnesses presented, no evidence presented. In fact, you're telling the very fine lawyers, both in the defense and the state, to stop working on this case because you wish to resolve it this way. Is that right?
That's correct, Your Honor.
You understand if you're not a United States citizen, this plea will be held against you in a deportation proceeding.
Yes, Your Honor.
And do you also understand, and this is a question I have to ask everyone, do you understand that if and only if in the past you'd ever been previously convicted of a sexually motivated offense, that this plea today will be cause for involuntary civil commitment due to the Jimmy Rice Act? Do you understand?
Yes, Your Honor.
Okay, I do find the plea to be freely, willingly, knowingly, intelligently, voluntarily given. I do find a factual basis for purposes of the plea, and therefore, I'll adjudicate you guilty, sentence you to 9 days in the Broward County Jail, give you credit for time served of 9 days, and order you pay court cost of $293. I'll give you 1 year to pay. Partial payments are permitted. Good luck, sir. And I do need his fingerprints for those at the jail. What? Yes.
No contest.
Yes, sir.
And I leave within a reasonable amount of time.
Yes, sir. Within the 6 hours. Okay?
6 hours.
Well, tell that guy behind you to hurry up.
Can't be 30 hours.
Good luck, Stephen.
Good luck, sir, really. And the man behind you can rush things if he wants. Okay. Yeah, you like that? Okay, Stacy Groover.
Come on, Lulu. That's not bad, Your Honor.
Hi, Miss Groover.
Yes, ma'am.
Good afternoon, ma'am. It's alleged that you had committed a trespass and failed to leave upon order of the owner. And I do find probable cause for your arrest, and your bond is only $25, ma'am. So you can post that. I wish you the best of everything. Thank you.
Judge, Ms. Groover indicated to me she may not be able to post that bond. Would the court consider resolving her case this afternoon?
What's her history?
Don't say anything just now.
I'm just going to tell you that I'm asking for the criminal history so I can decide if I want to do the taking care of it today. I'm not sure.
It looks like she has a pending DWLS in front of you, Your Honor. 2015 public aid fraud conviction. 2013 possession of hydrocodone conviction with the VOP. 2012 possession of oxycodone, cocaine drug paraphernalia conviction with the VOP.
When is he supposed to go to court on the DWLS?
One moment.
In front of me.
Next, she's scheduled for arraignment June 28th, next Wednesday.
Okay, respectfully, ma'am, I'm going to deny the request to resolve this at magistrates. I'll see you June 28th. Thank you. Thank you. Good luck. $25 will get you out of jail, though, on this charge. Probable cause is found. Christine Hilger.
North.
Thank you. Hi, Ms. Hilger.
Hi.
Good afternoon, ma'am. Apparently, you had a municipal ordinance case, 1600-6410-MO10A, and apparently there's
court date.
Yeah, right. There was a court date.
Your Honor,
Ma'am,
I
don't
was
say
trying to set up
anything.
somebody-
Ma'am, do
Okay.
not. Ma'am, do not
I was
say.
trying to set up somebody in the community to come with me because I don't have my mom and dad here. I'm on heavy psychiatric medicine, and I go crazy when I go to stores. I can't add up money. I don't know what the ending balance is. I don't at the end of the month. I'll go without money for 14 days. But I always keep changing my purse, and on these group homes, we're just taking everything I owned. My food and my shampoo and stuff. And I went crazy. I really went crazy. I was without doctor's attention. My insurance cut me off. I went to like 20 doctors because Dr. Psychowski I was with for 6 years. He retired and left Florida. So then the next doctor retired. And
Yes. Well, I do find probable cause for their arresting you, ma'am, because of the missing your court date for the petty theft charge.
Right.
However, I don't know if she needs to go to the other court if she's in Ginger Lerner Wren.
You can,
No, she's where. If I could just go to like a shoplifting court or something.
Well, ma'am, I'm not going to take care of it today because the judge had wanted a $250 bond. Let me see who that judge is.
Oh, really? On a bond?
Yeah.
I'll give you, because I'm trying to get somebody to come to court with me.
Well,
I
it's
have a
unfortunate.
dog, too. The weather's changed, actually.
Judge.
Yes. Is it Judge Ginger Lerner Wren?
Yes.
All right.
Yeah, because if you don't have somebody with you, she doesn't like to talk. She just says,
Was there a public defender in there that can talk for her when you go?
Judge, it's a municipal ordinance case, so
Oh, I
unfortunately
forgot.
we can't represent her. I do know that Steve Shates sometimes takes Oakland Park cases
Can
on
I appoint
as a
him?
friend of the court.
I can't appoint
she's a
him.
good person.
I'm sorry. Hold on, ma'am. Just give
Ma'am,
me
I'm
one
going to try
second.
to I'm going to try to get you a lawyer, so when you go in there, someone can speak for you. Is that good?
No,
Yes.
because she doesn't really do
Right. Maybe she'll let your lawyer talk. So can I do that? I'd like to appoint someone to talk for
Yeah,
her.
Miss Christine,
Okay, Hilger.
Christine, let me talk to the judge for a second, okay? Just give me a moment, all right?
Quiet 1 second, ma'am. You can stand there, though.
All right. Yeah, I don't know why you can't appoint him. I mean, I'm sure you
I'm gonna
can.
appoint him. She needs
It's,
help.
it's
so
City
I'm
of
gonna
Fort
give-
Lauderdale.
It's City of Fort Lauderdale.
That's where she was
says Oakland
arrested on the
Park.
Capias. It's City of Fort Lauderdale.
Oh, okay. Whoever I'm going to appoint. I'm happy just to get the lady some help.
I agree, Judge.
Okay, let me get back to her. Ma'am?
Very scary.
Okay, ma'am, I've gone ahead and ordered an attorney to help you. His name is Jared McLawrence. You're going to go to court on June 29th. Today is the 21st, so in 8 days you'll be in front of...
8 days?
Yes, and I do find probable cause. But yeah, okay, so...
I could bond out and get somebody, because
That-
I've got somebody in Chrysalis right now.
Good, do that too. I want you to do both. You'll have the attorney plus your friends. And it's
But my
200...
belongings are all, and my belongings are
Well,
all...
call your mom and
my
dad. Call your mom and dad.
They're not here in Florida. They're not
Well,
here.
they can
Nobody's
send
here.
money, or they can send
No,
money.
my belongings, all my clothes.
Okay, well, they're going to give that back to you if you bond out for $250. Thank you, ma'am. I wish you the best.
Okay, thank you.
Thank you. Bye-bye.
I-
Bye-bye. Apostolos Chakmakis.
He's North Broward, Judge.
Thank you. Hello, Mr. Chakmakis. It looks like there was a capias out for you on case number 170023828MM40A. The judge has ordered a $250 bond on that. It is an add charge, sir, to your other charge. So, including when you add the other case or your other charge plus this $250 bond, that I do find probable cause. I don't know what the other charge is and how much the bond is, but,
It's a $750 bond on a petty theft.
so it's $1,000, sir, you can get out of jail, okay? Thank you, sir, good luck. This is also a petty theft, thank you. Juan Valderrama?
Conti, Your Honor.
Hello, Mr. Valderrama, good afternoon. These are some ad charges for the allegation of violation of probation for a felony in 14-005009 CF10A. The judge in that case wants a no bond hold. Also, count 4 is an ad charge. I'm not done talking, sir. Thank you. Another violation of probation allegation for a felony of case number 14-006847 CF10A, and that judge wants another no bond hold. You'll be going to court June 28th at 2 p.m., sir. What did you want to say?
These are ad charges for when, man?
Right. I can tell you that there were some violations of probation allegations, and I'm going to tell you the warrant was signed June 19th by Judge Tobin Singer. Yeah, they just came up June 19th. Okay, sir?
But they're ad charges?
Well, they're the violations of probations for 2 different cases the judges signed no bond holds. You'll see her June 28th, and good luck, sir.
Okay, thanks.
Theotis Presby.
North Broward, Your Honor.
Thank you. Hello, sir. I also have an ad charge for you, a grand theft charge. I do find probable cause, and your bond is $1,000 for this new ad charge, sir. I wish you the best of everything. Thank you.
Yes, ma'am.
Now, is Stern Ferguson there?
Mr. Ferguson's here present, Judge. He declined to serve as the public defender, and I believe he's on 2 pages, on pages 4 of the docket, and I believe he's on page 9 of the docket, Judge.
Right, they're about the same case. So, Mr. Ferguson, it's the same thing on 2 different pages. Do you understand?
Yes,
Sir,
Your Honor.
count 1 is a criminal disclosure of warrants, subpoena, etc. I'm finding no probable cause as to count 1. And as to count 2, it's an out-of-county hold, sir, for a felony. And it looks like the case number is F1500. It's either 3367 or 8857. It's hard to read this.
3387.
Okay, 3387, thank you. And on count 3, and that's a no bond hold, by the way. That judge does not want you to have bond at this point. Another on count 3 is an out-of-county hold. Felony F14007910. Another no bond hold. I think that's out of Dade County.
Yes.
Sir, thank you. And therefore, sir, you have 2 no bond holds. I do not find PCS to count 1, but I do find PC for your arrest. And should I sign 2 or the same one?
It's the same one, Judge.
Yeah, I'm not going to do it. I'm just going to put them together. So, sir, until you see that judge in Dade County, you're on a no bond hold. Do you understand? PC's found on 2 and 3. Thank you, sir, and good luck.
Thank you.
LaReggie King.
Mr. King is here present, Judge. He declined to serve as the public defender.
All right, Mr. King, it looks like they charged you with felony battery. After looking at the probable cause affidavit, I do find probable cause. And what is Mr. King's history?
Well, it appears Mr. King is out right now on a felony possession of codeine, resisting without violence 2010, disorderly conduct, resisting without violence 08 conviction, resisting without violence, disorderly conduct, withholds 08. I can also advise the court, according to the Florida Department of Law Enforcement, as of May 9th this year, Mr. King is a registered gang member in the state of Florida. And, one moment, Judge. There's a warrant for his arrest out of Georgia from September 1st of 2016.
What's the bond on that, if any?
One moment, Judge.
And was he on bond on the codeine, the felony amount?
One moment, Judge.
And how much?
I understand. He's out on a $1,000 bond on the warrant out of Georgia. I'm not showing a dollar amount. It's in-state pickup only. So
Okay, that's fine. All right. So, sir, you're on bond on a felony case that's pending, and based on your new arrest on this felony battery, I'm revoking that bond and holding you no bond till you can see the judge in that case to let them determine what they want to do about the allegation that you've committed a new offense while out on bond in their division. What is this? I don't care what court it is. It's a violation of the conditions of bond. Now, what is the state recommending for the felony battery?
Your Honor, I'm going to be recommending a $15,000 bond. I understand he was charged with felony battery. There's allegations that he used a weapon in committing this offense, Your Honor.
And he's refused the public defender's help.
Yes, ma'am.
Yes. Sir, I believe under the circumstances and the weapon they alleged to be used in this incident is very serious, and I think $15,000 bond is appropriate in the circumstance. I do find PC for your arrest on this charge. But as I said on the other case, can you please give us the case number so you'll do an order for me?
Yes, Judge.
And for the record, please.
1610259 CF10A. And, Your Honor, the state would just also obviously request an order of no victim contact.
And no victim contact in the case of the felony battery. You understand, sir, that person who is alleged to have been beaten and allegedly been, with the gun whip, with the firearm, that you have no contact with them whatsoever. Understood?
Yes, ma'am.
Thank you, sir. Thank you, sir. I wish you the best of everything, sir. Thank you. Next is Markeith West.
Mr. West is your present judge, I mean.
Now, Mr. West has some family here. Yes, Your Honor. Do they want to come up?
Mother is here along with other family members.
Now, did Mr. West wish to have the services of the public defender?
He does, Judge.
Thank you. All right, ma'am, please come up right there is good. And are you his mom on the right? Okay, and you're his sister? His wife?
His girlfriend.
His girlfriend. Okay, I just didn't know.
It's okay.
All right, I don't know who's going to speak on his behalf, but if you wish to, just raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. All right, what is your name?
Alexis Bowler.
How do you spell bowler?
B as in boy, OHLER.
Thank you. Now, Mr. West, it's alleged that you committed a felony battery. In reading the probable cause affidavit, I do find probable cause for your arrest. Now, may I ask the state, what is his history?
Yes, Your Honor. The state will also be seeking a $15,000 bond from Mr. West. His criminal history: 2012, aggravated assault against a law enforcement officer. He was convicted, violated his probation, was sentenced to just over 29 months state prison. 2012, robbery by sudden snatching. With the violation of probation, conviction, received the same prison sentence. You want
Give me a second. Go back to that last one.
Okay.
What was the last one?
It was a 2012 robbery by sudden snatching.
That's what I wanted to.
Violated probation, received the same prison sentence concurrently. 2011 strong-arm robbery and battery against a victim over the age of 65. He violated probation. That case was sentenced to 29 months. Your Honor, based on his 3 violent priors, the level of violence alleged in this case, where he allegedly punched and kicked the victim while he was defenseless on the ground, and the strength of the evidence, considering, according to the report, both Mr. West and his co-defendant admitted post-Miranda to committing the offense against the victim.
In regard to that, as far as the strength of the case is concerned, I would point out that according to the probable cause affidavit, the officer writes, due to the victim giving conflicting statements, he was only able to articulate a felony battery. So the victim himself is not even telling the truth to the police in this case, Judge. So I think when Mr. Lender says that he has the strength of his case and talks about it, it sounds to me as though it's not such a strong case. In addition to that, what Mr. West and what Mr. King said was that the altercation occurred after the victim initiated a verbal altercation with them. So I think there's a lot of issues to be determined here as to what actually happened. But I certainly don't think that the state can stand there and say, hey, this victim is a classic victim. He's a great victim, when even the officer himself says inconsistent statements.
Well, I hope no one is.
And I don't believe I said, that he's a great victim. I don't know that I would ever refer to any
I don't believe
victim as a
anyone's
great
used
victim.
that term in here. However, other than just now in his argument. Okay, but besides that, I do find probable cause for the arrest. However, I haven't heard where this particular defendant was out on bond for anything else.
I'm not saying he was out on
No,
bond.
I'm speaking out loud just to make sure I'm making a record. That I don't know that he's been in any way affiliated as a gang registration, just for him. He does have a history, however. I did note what Mr. Reedy had noted. However, I think this is still serious in nature, if indeed that it's, the allegations are that based on a verbal altercation that this ensued, based on everything that's alleged, I'm requiring a $10,000 bond for Mr. West. And I thank you ladies for being here, but he can get out of jail for a $10,000 bond.
State would request no victim contact.
And of course, no victim contact with the individual who's claiming to be the victim. Okay, Mr. West? You understand, right? Thank you.
Yes, ma'am.
Because that'll violate your conditions you don't want to violate. Albert Remy?
Mr. Remy? Come on up.
Mr. Remy, good afternoon. It looks like they allege you have a violation of probation for a felony in 1401178 CF10A, and that judge is seeking a no bond hold at this point. You will go to court on June 26th at 9 a.m., sir. I do find probable cause for your arrest. Good luck, sir. LaGary Roberson.
Mr. Robertson, come on up.
Mr. Roberson, good afternoon. Count 1 is allegedly a robbery with no firearm or weapon. Count 2 is an aggravated child abuse. Count 3 is a touch or strike battery. Count 4 is a possession of PVP. Count 5 is resisting an officer without violence. Count 6 is a probation violation or community control violation for a felony in case number. I think it's a 1500714 CF10A. In the probation violation and community control violation allegation, that's a no bond hold, sir. You'll have to go to court on that June 29th at 9:45 p.m. to discuss that with the other judge. However, as to the touch or strike battery, that's a $1,000 bond. The possession of PVP, that's a $1,000 bond. Resisting, obstructing an officer without violence is a $100 bond. But back up to the robbery with no firearm or weapon or aggravated child abuse, I'm going to ask his history.
Your Honor, he's on probation. I know it says battery. I'm showing he's on probation for felony battery due to priors. 2011, resisting without violence and assault on a law enforcement officer. 2008, aggravated battery.
And these dispose on the ag battery?
The aggravated battery, he received a withhold 2 years probation. He received withholds on the resisting without violence and assault. He was convicted of the felony battery. He's on probation. And it looks like...
He's on probation right now on the felony battery?
Yeah, that's count 6, Your Honor.
Oh, I see.
And
That's
if I
that
just
case.
have one moment, Your Honor, I just want to...
Sure.
Judge, the only thing the defense would be requesting at this time would be a photo order.
That's granted.
And I can advise the court... He's already violated that
But
probation one.
I imagine that since it's already in existence before these charges, so. Right, there's an allegation of some other violation before these charges even exist.
What was there?
It's got a warrant.
No, he wasn't arrested on a warrant, Your Honor. He was arrested on a warrantless arrest under 94806.
Okay.
But what I'm saying is he already had a prior violation where he was found in violation of his probation.
Oh, I see. So this is a different one now.
This is a second
I
alleged
get it.
violation.
Okay, so now what is your recommendation knowing his history for the robbery, no firearm, no weapon?
Based on his history and the robbery and taking into consideration the allegations, the age of the alleged victim, Your Honor, I'm going to be seeking a $20,000 bond on 1 and a $5,000 bond on 2.
Did he accept the help from the public defender's office?
Yes, Judge.
Tell me something about his ties.
He's been residing here his whole life, but unfortunately he told me at this time he's unemployed, no money in the bank, no property, nobody that he could potentially call to help post his bond. So for all practical reasons, he's financially indigent.
Well, based on the charges and the allegations, the nature, his history, safety of the community concerns, As to count one, I'll make it a $10,000 bond, sir, for that robbery with no firearm, no weapon. Count two, the aggravated child abuse is a $5,000 bond. And I'll keep this battery at a $1,000, the possession of PVP at a $1,000, and resisting without violence at a $100. And again, sir, you have to talk to the other judge about that no bond hold based on what looks like a second violation of probation. No contact with the victim, sir, and I do find PC on all counts. Thank you. Raymond Rosario.
Mr. Rosario is approaching. Judge, the client serves public defender. He says he has private counsel.
Is private counsel here? All right, Mr. Rosario, good afternoon.
Good afternoon.
All right, sir, you're charged with possession with intent to sell, manufacture, or deliver THC. It's within 1,000 feet of a school or park or a child care. However, I'm not finding probable cause of the withhold within 1,000 feet of a school based on the idea that it was a traffic stop that happened to be there and you were a passenger in a vehicle allegedly. So I do find probable cause of the possession with intent to sell, manufacture, or deliver THC that I will find probable cause for, and that's going to be a $5,000 bond. And as to the drug paraphernalia, a $100 bond, and resisting an officer without violence is a $100 bond. So your total is $5,200 you can get out of jail in this particular case. Okay, sir? Thank you. Wish you the best of everything. Thank you. So that I did, Mr. Linder? Yes. All right, next is Ainsley Howell.
I've been a high C bondage judge.
Okay, very good. Okay. Akeem Cohen's.
Mr. Cohen is here, President Judge of Maine.
Thank you. I'm sorry? I believe this lady's here as well.
His mom.
Okay, your mom is here, sir. Let me share with you the charges. Sir, it looks like count one says you were in possession of a counterfeit credit card, invoice, sales, or draft voucher. That's a $1,000 bond. Count two is that you were in possession of a counterfeit credit card, invoice, sales, draft, or voucher, another $1,000 bond. Count three is a counterfeit credit card, invoice, sales, draft, or voucher, another $1,000 bond. And count four is a counterfeit credit card, invoice, sales, or draft, or voucher. That's another $1,000 bond. And your possession of cannabis, charge number 5, of 20 grams or less is a $100 bond. And I did find probable cause for your arrest on all counts. Sir, somebody apparently has posted your bond.
Can I
Yes,
say-
ma'am. Please do me the biggest favor, raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth.
Yes. My son never ever been arrested. He works for the county, so is I. And he was called that night to bring his friend book bag to him.
Don't discuss the facts of the case,
Okay.
ma'am. His bond has already been posted. He's getting out of jail, and we've won.
Okay.
Okay, so there's no need
Let
to
him
really
get out
say
of jail.
anything
Let
else.
him talk to an attorney or whoever. I know the public defender's helping him today. If he's seeking the public defender's assistance, please let him share that information with them, and they'll do the proper paperwork, motions, get him to trial, whatever it will take. But that is the time to tell all that, not right now when we're being recorded, and I can't help him today on anything else. Okay? Thank you so much. Nice to meet you, ma'am. I apologize, ma'am. I do need your name for the record. Ma'am, I apologize. I need you to state your name for the record. Thank you. Thank you. Your name, ma'am.
Cunningham.
Ms. Cunningham, thank you for being here, and whoever else was in support of Mr. Collins. Thank you so much. Nice to meet you all. Thank you. Sir, you've been bonded and hopefully be out very soon. And, make sure you do everything you need to do to get to court and take care of this matter, okay? Please make sure you appear to court. Thank you.
Good luck, sir.
Good luck. Felix Perez. Is everything
He's in
good?
Conte,
Yeah.
Judge.
Yeah, somebody already posted the bond, man. He'll be getting out. Thank you so much. I wish you the best, ma'am. Did you say Conti?
Yes, ma'am.
Hello, Mr. Perez.
Yes, ma'am.
It looks like there's a charge now. It was once charged as burglary. Now it is attempted burglary of a conveyance on unoccupied dwelling at 1700 57 19 CF 10A. And the state have a recommendation as to a bond?
Honor, Judge Gottlieb had set the bond at $5,000. I'm asking that be set back on him. I provided court with a copy of the PC. As you can see in the PC
Yes, I
affidavit, it's
saw it.
clear there was an attempt. And I believe Judge Gottlieb was also, he heavily factored into Mr. Perez's criminal history.
Yeah, that's what I was going to ask you as well.
He has a pending attempted burglary of a conveyance in addition to this case.
Do I sign it?
04, burglary of a conveyance and grand theft. He was convicted. He was sentenced to 5 years in state prison and qualified as a
Mr.
habitual.
Linder, give me a second.
Oh, sorry.
But I didn't tell them what the charges are. They already bonded. I mean, I'll sign all of them, but when I was supposed to, I thought it was when I told them that they got to be written down who told them. I never told them. But I did make a PC determination, if that's all you want. Okay? All right. Please continue. Start again.
Okay, I'll start over. Mr. Perez is also being held on another separate attempted burglary of a conveyance. 2004, he was convicted of burglary of a conveyance, third-degree grand theft, sentenced to 5 years state prison as a habitual offender and qualified as a habitual offender. 2004, burglary of a structure and felony theft. He was convicted on both counts, sentenced to 5 years state prison as a habitual offender. 01, grand theft, 8 conviction, 18 months state prison. 98, burglary of a dwelling, convicted, sentenced to 30 months state prison as a habitual offender. 97, burglary of a structure, convicted, 18 months state prison as a habitual offender. 96, he was convicted for burglary of a conveyance and grand theft. 96, convicted of burglary, conveyance, and petty theft. 95, he was convicted of burglary of a conveyance. Another 95, burglary, conveyance, and grand theft, convicted on both counts. Petty theft, 94, he was convicted.
It's okay. I believe the $5,000 bond is appropriate in the circumstances, sir. I do find probable cause for your arrest, and therefore, wish you truly the best of everything, sir. Thank you. Is Samantha Keeble there? Where's Miss Keeble? Thank you. Hi, Miss Keeble.
How are you doing?
Good. Have they charged Miss Keeble?
One moment, Judge. Your Honor, and information has not been filed on these charges. I'm just checking. Okay, that's all I see. She's being held on, Your Honor.
All right. Motion for ROR is granted, ma'am. They're going to send you your paperwork in the mail, and you must show up to court if they choose to file the charges. Okay, ma'am?
Is that dealing with my possession and
yes, ma'am. It was possession of
the
cocaine.
prostitution?
Looks like you've already completed your sentence on that, ma'am.
And
No, I have a second prostitution charge.
and then there's a drug paraphernalia possession. However, ma'am, they have not filed the charges. Therefore, I'm granting you the motion for release under unrecognizance. But if they do choose to file it, please make sure you go to court so you don't have any warrants that put you back in jail. You know what I'm saying?
Okay.
Yeah, you're being ROR'd on everything.
On everything. And good luck, ma'am. Good luck. Congratulations. Thank you. Now, I'm on the second look, so I've only got 2 left, as I can tell. A Chesdin Murray.
Chesdin Murray's here, President Judge at Maine. Come on up, Mr. Murray.
He's done 4 days. Hello, Mr. Murray. Let me ask, the state, what are you seeking in this battery charge?
Your Honor,
As a bond? What was the bond?
I'm just asking that the bond that was already set
What
be
was
kept in
it?
place. Does confinement status have it? On one moment, Judge.
Do you know it's Murray, Mr. Murray? How much is it? The bond? 1,000?
Yes.
What's his criminal history? Mr. Linder.
One moment, Judge.
I only said Mr. Linder so everyone knows I'm talking to you.
He has a pending felony,
4.
possession, resisting with violence. 2013, burglary of a dwelling, burglary of a conveyance, and resisting with violence. He was convicted on all counts. 2012, possession of cocaine, he was convicted.
All right, I think $1,000 is very reasonable after a second look. I still don't think $1,000 is appropriate. Sir, of course, probable cause is found. $1,000 bond still outstanding. you can get out of custody on that particular case for $1,000 bond. Thank you, sir. I wish you the best of everything.
Yes, ma'am.
Thank you. Xavier Ingles or Ingalls Ramirez?
Conti.
Hello.
Hello.
We're here for a second look. Have you filed on Mr. Ingalls Ramirez's petty theft?
He was just arrested on the 18th. I think actually Your Honor said
May
his
18th or June 18th?
June 18th. Your Honor said his bond at $100 on Monday.
Okay. And, sir?
This,
Yeah. No, I was going to say, what's his history? I mean, $100 seems fair.
I'll check this. This will probably refresh your memory. This involved he allegedly took a cab from Miami.
Oh, yeah.
To
I
the Sawgrass Grand
yeah,
Hotel.
Yeah, to a hotel, and then said his friend was supposed to pay it, but then he didn't. Yeah, that was. I remember that now.
Like $109.
All right. Do you have any history of him?
I'd have to run him in the system. There's no.
Oh, I say you don't have anything now, but I understood he was kind of traveling. All right, sir. I think that this. You know why we're here? That same petty theft case of the alleged failing to pay cab fare, right?
Yes, ma'am.
Okay, the $100 bond, after remembering the facts of the case, remembering the circumstances surrounding it, I do believe the $100 bond is fair, and I did find probable cause, and therefore, sir, I think the $100 is still appropriate after a second look. Thank you, sir.
Javier, is there anybody I can call to come up with $100 to get you out?
I have no family down here or friends.
Anybody anywhere?
How about somewhere else where they can send a money order or somehow get money down here? I don't know, where do they accept those wires of money funds? Because, sir, if I recall correctly, the allegations were that the cab fare was over $100. So, you know,
$109.
just to let you know, I remember the facts very well. Okay, so Mr. Reedy's trying to help you. Thank you.
Can you give me any phone numbers anywhere, Javier?
You can try my mom.
Okay, what's mom's number?
727-421-9333.
9 what?
9333.
9333.
Okay, what's her name?
Lucy.
All right, I'll give your mom a call, see if she can come get you.
Thank you, sir. Good luck.
All right, good luck, man.
Bye-bye. Thank you, ma'am.
Thank you. I think that's everything. Am I right?
Actually, we have one more gentleman, Eric Stortz. He's here at Maine.
You know, they keep putting him on for.
Second look, but no, yeah, he was actually supposed to be put on today. They accidentally brought him yesterday, a day early, but he went this morning to his regular assigned judge. He resolved his case for withhold court costs.
And is that the case that was in front of me?
Yes, the trespass.
And so why is he still in jail?
Actually, it wasn't a trespass. We drive without a license.
Driving without a valid license. I don't know why he's still in jail.
Well,
I hear an alarm going off at the jail.
They may be. I mean, even if he resolved the case, they still have to just run it through the system, make sure there's no outstanding warrants.
Okay.
They just don't walk to the
So
front door.
we have nothing to help him with today. It's already been resolved.
Nope.
Thank you, sir. I wish you the best of everything, sir. Pleasure to meet you. Take care.
Yeah, but here,